Thank you very much, sir. Am I audible?
Yes, Krishna, you're audible.
Good morning, dear participants, all the faculty members, research scholars, whoever has joined from various parts of the country. We are so thankful for your active participation and interest for joining this 7 days FDP program. With an uplifting inaugural session, we are going forward to the first session of the FDP program, 7-day FDP program. So we will be having Lalit Kumar sir. He will be talking on Introduction to Intellectual Property Rights, Importance and Scope. Sir, Professor Lalit Kumar sir, are you in the meeting?
I called him. He's joining. Sir is joining.
Okay, sir. Yes. We will start the session the moment sir joins.
Am I audible?
Yes, sir. You're audible, sir.
Namaste,
Can you
sir.
see me? Namaste.
Yes, sir. We can see you, sir.
Okay.
Good morning, sir.
Sir, you're perfectly
morning.
visible and audible. So,
Dear
Krishna, you can
participants,
carry
so
on.
we have Professor Lalit Kumar. Professor Lalit Kumar Dev sir has joined. Namaste, sir. We welcome you to the first session of the FTP program. I request my friend, colleague, Mr. Ramanamurthy to introduce the respected resource person of this session.
Good morning to all. It is a great opportunity to introduce today's renowned resource person, Professor Lalit Kumar Dev sir. He is presently working as a dean at Birla School of Law, Birla Global University. He has a teaching experience of about 36 years. He worked as a professor and head of the undergraduate legal studies at Maharashtra National Law University, Mumbai. He has also served as the principal Lingaraja Law College, Behrampur. After completing his master's with a specialization in international law from Andhra University, Professor Dev sir worked as an advocate for a few years. As an academician, he has served at the Premier Lingaraja Law College, Behrampur for 32 years. In 1991, he was appointed as Reader cum Principal of Lingaraja Law College. Professor Dev sir has also been a member of the Juvenile Justice Board, Ganjam District of Odisha for consecutive 2 terms. Thank you for giving this opportunity, sir.
Thank you very much. Shall we start? Can you hear me? Can you hear?
Sir, yes, sir. Yes, sir.
I'm audible.
Yes, sir. Yes, sir.
Okay. Now let's start. Thank you for giving me the opportunity to be present here. It's a nice morning to meet all of you. Very good morning to all of you. And I've given the task of giving an introduction to a very complicated area of law, intellectual property rights. So let's begin with understanding the 3 words which are there: intellectual property and rights. So what is that intellectual thing? Intellect, intellectual, whether those who are not intellectuals, they have certain rights. Whom do you consider an intellectual? There are people like farmers, workers, who come upon certain things. So whether the things they come across, because generally you come across farmers, that is, they without application of the mind or by practice, they develop certain new varieties of seeds which they do not understand what that seed is. Since generations, it is there. So that also is considered within intellectual activities. So intellectual is generally something connected with the mind. Mind, especially the major part of the mind where the particular activities go on according to Sigmund Freud is the subconscious mind. So many things are there in the subconscious mind. So whether something which is retracted from the subconscious mind can be considered as an intellectual activity, this is another thing. Because now we have this brain mapping. Brain mapping is there, narco-analysis is there, where that is something which is there inside the mind can be extracted. Something which is there inside the mind can be extracted. So whether someone was extracted something from inside the subconscious mind of a person can use that particular thing for a particular, take advantage of that thing and develop a particular type of, that is intellectual property. So many things are there, but our, that is, focus is on, that is the creations from the mind. The intellectual property generally is, intellectual is something where, that is, the mind is used, something which comes from the mind, which is a creation from the mind. That is intellectual activity. We'll go into the details, we'll go into the details, but not into the depths. The depths will be taken up by other, that is academicians who shall be, that is taking up in different sessions, the different areas of, that is intellectual property rights. We will only, that is, go into the surface, the broad surface, the bird's eye view of what intellectual property rights are. So second aspect is the property. There also you come across that intellectual property is something different from the common concept of property. It is something different because your ordinary property you can keep in the locker. You can, that is, prohibit others from using it. But it is not so easy with regard to intellectual property. And third aspect is rights. That is also a very broad concept. Rights, different levels are there, human rights, legal rights. So how do you look into those rights aspects with regard to intellectual property? So these are certain things which we shall discuss not in depth, but a bird's eye view or an overview of the entire arena with regard to intellectual property. So first of all, that is one thing you remember, that is every year, that is one day we celebrate as Intellectual Property Day. That is 26th April of every year is celebrated as Intellectual Property Day in order to remind the people, in order to, that is, bring awareness among the common man with regard to the intellectual activity and the intellectual property rights. So now we come to this, the development of intellectual property. you come across in ancient times. Ancient times when all this new technology was not there, common technology was not there, everything was prepared with great difficulty. A painting, a painting, a work of that is literary work, say Shakespeare, that is used to write the entire work. So that time, all this modern technology with regard to printing was not there. The machinery was not there. The technology was not there. But then too, that is, people wanted that their works should not be abused, because generally that is, it was difficult to copy a particular person's work, because when this palm leaf was there, people used to write on papyrus, that is paper made from that is bamboo or other things. They used to write on rocks. They used to write on that is copper plates. So those things generally it was difficult to that is copy those things. Then too that is there were certain paintings. You come across unique works. So how that is paintings were protected? Generally, that is paintings they were protected by writing the signature of the artist at the bottom. But you come across that once that is the process of printing developed, lithoprints, their copies came up quickly. That time it was difficult. One painter that is in India, you come across Raja Ravi Verma. Raja Ravi Verma, his paintings, they cost crores in the international market. And also you come across duplicates of the painting in the market with the exact copy of the signature. But generally that is the identification of the particular art. There, now that is it has become easier through carbon testing and others. But here generally these were the means by which that is generally earlier times they used to protect the art or a particular style. Every artist used a particular style. A particular style was used. Say with regard to this, you come across one Ganjifa cards. Ganjifa, that round cards which was played during earlier times, people used to play cards. So at that time, this Ganjifa card, you come across different varieties were there. That is in Karnataka, one style was used for the Ganjifa card. In Odisha, another style was used. Or with regard to paintings, different styles were used. So from the particular style, the particular, that is, area from which or the artist who made it, it was known. Or with regard to architects, they used to, that is, use certain patterns. And these patterns, that is, they were unique for each artist. Then you come across with regard to gold and jewelry. Gold and jewelry, that is, the different marks were used on the particular gold and jewelry in order to, that is, identify the particular jewelry as made by a particular person. Even now, you come across this hallmark and the particular identification mark which is made compulsory on the particular jewelry. This was used since ancient times. Since ancient times, that is, particular jewelry used to be marked. So these were, that is, certain ways by which, that is, the particular intellectual property rights, they were protected in ancient times. And in order to protect them, that is generally you come across that the state originally, they used to make certain rules with regard to, that is, copyrights, with regard to authorship, with regard to ownership. In that is writings you come across at the end of the poem, many writers used to, that is, express their names. In the poem itself, you used to come across the name of the particular, the author. So in that way, that is generally the rights used to be protected. And now coming to this, what is the nature, what are the ingredients of intellectual property? The particular requirements to become an intellectual property. First is, we have discussed the creation of the human mind. Intellectual property is connected with the originality which comes from the human mind, the thinking process, the subconscious mind, so application of mind, use of some type of techniques, use of a particular process. So later on, you will come across the difference between an invention and a discovery. Discovery is something which already exists. Invention is something which you develop through following a particular logical steps, whether it is biotechnology, whether it is science, chemistry, other fields. So here generally you'll come across those inventive steps. Later on, when you come across that is experts who will be talking on patents, you'll come across discovery. How discoveries also can be patented. In patents, you will come across this that is generally microorganisms. Microorganisms, that is, you don't create them, but when you discover a particular type of microorganism, then generally that is patents are allowed in certain cases. But that part you will come across in depth when you come across the, that is with regard to the patenting of microorganisms. When you come across the patent area, then you come across the nature of the property. Sometimes you come across that intellectual property exists within physical property. Intellectual property sometimes exists within physical property, and sometimes it is independent and intangible. When it exists inside, because supposing you have a vehicle, inside the vehicle, you come across that different types of intellectual properties are brought together to make the particular vehicle, the engine, the carburetor, the particular, that is, different components of the particular, that is, vehicle. So also with regard to the computer, the different parts of the computer, each of them, that is, has a unique intellectual property element in them. So sometimes intellectual property exists within physical property, and sometimes intellectual property exists beyond the particular physical property, the right. So also with regard to, that is, a book you write, a poem you write, that is, once it is put in the form of a book, your intellectual property enters into a physical form. Intellectual is property, the soul, the book is the body. So intellectual property sometimes, that is, becomes the soul of a particular physical body or property. Sometimes, when, as long as it is not used, the intellectual property remains as a soul without being used. So intellectual property is the soul of many physical properties, and physical properties, they contain the intellectual property rights of the creator. So then you come across that intellectual property rights, they are not like other rights, like human rights, fundamental rights, or other forms of rights are there. They are a different types of rights. they are exclusive rights given by the state. That is, if we talk about human rights are those rights which a man possesses as being born as a human being. By birth, he has certain rights. But generally, the nature of intellectual property right, although it is brought under the Human Right Universal Declaration of Human Rights, there you come across that intellectual property rights also find a place. Intellectual property rights also find a place in Universal Declaration of Human Rights. But intellectual property rights are different from the human rights and fundamental rights. You'll come across that. But here it is an exclusive right given by the statute, can be taken away by the statute after a particular period of time. But human rights, fundamental rights, they are not given by the state. State does not give you right to life. State does not give you the freedom of speech. State only that is provides that it will not interfere with your right to life, with your right to liberty, with your right to that is speech, with your right of movement, without that is reasonable, without proper reasons. But in case of that is the intellectual property rights, the state says you will enjoy your right for 20 years. You will enjoy your right for 50 years. So here state says that you have a right for a particular period only. And beyond that period, your right is taken away. But you cannot do that with regard to other human rights. And this right, that is a right given by statute, not by birth. Then you come across that it has particular, that is intellectual property rights. They are subject to certain limitations and exceptions. When you can exercise, when other people can exercise on behalf of you, you'll come across compulsory licensing. Compulsory licensing. When a particular that is intellectual property is essential for the people at large, and the particular intellectual property is not being used, there generally that is state can, that is the government can, that is give compulsory license to another producer, to another printer, to another that is business enterprise in the interest of the public. So here generally certain limitations, certain exceptions are there, certain conditions are there, but in human rights, no conditions are there. Life, no conditions. State cannot say under these conditions you will live. So, and then you come across that human rights, they are not time bound, but intellectual property rights, they are bound by term, by time, for a particular term. Beyond that term, your right does not exist anymore. Say 20 years in regard to patents, copyright, lifetime of the author, plus the minimum is 50 years. By TRIPS, India, it is 60 years. And 60 years was made because of Shantiniketan, because Rabindranath Tagore had left his works to, that is the rights were given to Shantiniketan Vishwa Bharati in Bengal. So there, after 50 years was over, the Shantiniketan, they wanted extension of time. So it was made 10 years more. So for 60 years, the Shantiniketan had the rights over the works of Rabindranath Tagore. And after that period, the particular rights have been, it is now anyone can publish books on the works of Rabindranath Tagore. But that rule with regard to 60 years, it still continues under the Copyright Act. And another thing is that the intellectual property rights, they are territorial. Territorial means that is, even though will come across this TRIPS agreement, number of international agreements are there. But here generally those, because the intellectual property rights, it is a mosaic. Intellectual property rights can be said to be a mosaic. Number of international conventions are there, regional conventions are there, and ultimately it is for the state to make the laws in accordance with international guidelines and laws. So those who are member parties of international organizations, international conventions, they have to ultimately implement the minimum standards. So here you come across that intellectual property rights. It is that is a mosaic of international norms, regional norms, state norms, practices, traditional practices which are going on, and number of conflicting conventions are there. Number of conflicting conventions are there. Number of conflicting treaties are there. Number of conflicting laws are there. Conflicting laws, different laws, they provide different terms. And one protects another. We'll come to that soon. So here you come across, that is, these are the nature, and especially when you come across this intangible property. That is, tangible property is something which you can touch and see. You can touch, see, you can lock it up in your locker and not allow other people to enter into that property or take the particular thing. But intangible property is something which you cannot keep under your control. Intangible property you cannot keep under your control. Once you leave it, say a poem, you write a poem, put it on the social media, on the Facebook, or that is on some Twitter. So immediately that is a person in Australia, a person in Canada, a person in UK, all of them can, that is, download that poem, or they can modify it, they can publish it. Or supposing you prepare, that is a lecture, and put it on the YouTube, immediately others can, that is, easily copy it out. It is no more under your control. And you cannot know, you cannot find out who are the persons who have copied. Someone, that is, you write a particular article in India, publish it. Immediately someone in Canada will download the article. And now that is, you come across that intellect is not required very often. You give a title in certain software like ChatGPT. You put something and you will get a particular, that is, article, particular, that is, some work. And now the question will come up, that is whether something which is created by ChatGPT, you have, that is, and you get a printout, you publish that article, whether you have a copyright over that article or not, because it is not created by your intellect. ChatGPT, you can give some matter and ask him, that is, ask the ChatGPT or other number of other softwares are there, where that is, you can easily use to write articles. And that is, the Turnitin and other plagiarism checks, they will be unable to, that is, find out the particular, that is, your use of the ChatGPT. They will think it is your original work. But whether that is, it is your original work, whether it is an intellectual property, that is the question for future days. When the software, other that is new techniques will come up, where that is you just put an idea, give a that is command, and you will get an article. Because that is very often you come across that that is once you copy someone's article, feed it into some software, immediately it will change some words, and one article was there which was fed, and that is wherever it was with regard to women, wherever this woman was there, the software changed it to lady. That is, every third word it changed into something, and woman was changed to lady. And like this, with slight change, that is, you get a new article which is beyond plagiarism. So, like this, you come across that times are changing, and together with technology, together with developments, the law also has to keep abreast. The technology for that is to detect the misuse of the intellectual property right, that also should develop, because techniques for developing or copying, they're increasing. Piracy, they're increasing, but detection of those things, because now that is you come across new developments in cyber frauds immediately. That is uh, so immediately when that is um, you call or a phone call comes, and or a message comes, and you download the message, immediately your all the works, they disappear, or that is your accounts will be hacked. So these are new techniques which are developing, science technology is developing. So also that is protection should march together with the developments in science and technology, because good things are there, bad things are there. Many of the science and technology developments, they are misused. Even that is the Nobel Prize winner, he was that is uh, he did not expect that his dynamite would be so successful and would be so misused. So there, that is there was a story with regard to his how he that is changed into gave all his property to the Nobel Prize, because once there was a rumor that the Alfred Nobel, he had died. So in the newspapers, it was published that the uh, the killer, the human killer, has died. So when he read this, he felt that how the people, they look at him as a destroyer, that is someone who destroys people. So immediately he donated all his money, and he that is established the Nobel Prize for that is peace and literature. So like this, you come across that science, technology, they are developing in for good things, also for destruction, wars. Now we are in a crisis. You come across nature, everywhere problems are there. Many things are happening which never happened. Unexpected things, they come up. So that is, you come across that science, technology are developing not only for good, but also for evil. So also with regard to this plagiarism, other things, that is copy, or with regard to that is use of another person thing without acknowledging his rights over the thing. All these that is are now developing rapidly. Then we come to that is we have discussed what is intellectual property. Then we come to that is what are intellectual property rights. Generally, broadly, that is a person gets two types of rights. First, he desires a person, what does the person desire? He desires that, first of all, when he writes a book, why do you write a poem? Why do you write a novel? Why do you write a book? Why do you write notes? So, first thing is you want that is to be acknowledged. You want to be acknowledged. Society must acknowledge you as a writer, you as a poet, you as an artist, you as a singer, you as a musician. So first thing is you want that is to be known, to be known, to be recognized, to rise in society. So that part is your moral right. Moral right, which cannot be taken away, which cannot be taken away by others. Even after the person dies, his moral right remains with him. Shakespeare has died long ago, but Shakespeare's plays you cannot, that is, use a particular poem, write your name there, because moral rights remain with the author till eternity, till society remains. So you come across that the moral rights, they are rights not for a fixed term, they are rights in perpetuity. Even that is a person, the law is there that during the lifetime of the person and 50 years, 60 years after the lifetime of the person, you come across some people, they have given away their poems to the public domain. Subramaniam Bharati, that is, he in his will he said, all my poems are dedicated to the nation. Any publisher can print them, anyone can use the particular poems. So that is beyond that time, till that 60 years, the other interest remains. But the moral rights, the recognition, Mona Lisa painting, you cannot copy Mona Lisa painting and put your name there. You cannot copy Ravi Verma painting and put your name there as your original creation. When you copy the work, you have to use forever the particular name of the author, and that is the moral right, right to be recognized by society. The second right is people do many things, people create many things, people discover many things. During COVID time, why did they that is work for this vaccines? Why? Number of companies they started doing, that is Pfizer, Moderna, in Russia, in other countries, they started that is doing research on vaccines, because at that time that was the hot cake. Even without the regular, that is the particular period of that is by which it should be tested. Immediately, within 2-3 months, testing was there, and immediately it was left to the market, because that time it made that is huge profits. So the second right is the commercial rights. When you create something, that is, you want money, you want benefits, and very often that is huge amounts are spent. Research and development, millions are being spent to develop new things, to develop new technologies for health, for safety, for that is development, for improvement. So that is the two rights. Generally, broadly, two rights are there. One is the moral right, which is there with an individual, and that is forever. As long as humanity exists, humans exist, the particular moral rights, they remain with the author. Shakespeare's rights, moral rights, they continue. Rabindranath Tagore's moral rights continue. Leonardo da Vinci's moral rights continue. Very often you come across that you must have heard of Vincent van Gogh, Dutch artist. That is during his lifetime, he did number of paintings. Number of paintings were made by Vincent van Gogh, but he died as a pauper. Vincent van Gogh died as a pauper. He became insane. He became insane. And he cut off his own ear. Then after his death, that is, paintings with the name of Vincent van Gogh, they were sold for crores. Those who had his paintings, they sold them for crores, even though he died penniless. But that is, you come across because here generally, even though he did not earn anything commercially, but morally, he had earned a lot. His works, they are worth millions. That is Vincent van Gogh. On his life, one book has been written, Lust for Life. Lust for Life, in that book you can come across the that is life of Vincent van Gogh. Because generally works of art, works of literature, very often they get recognized after the person's death. Then coming to that is the human rights and intellectual property rights. You come across that is human rights, they have developed in a separate stream. Right from the Magna Carta till the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, International Covenant on Social, Economic and Cultural Rights in 1966. So that is a different branch. But in that is 1948, when the Universal Declaration of Human Rights was adopted, at that time you come across that the question of intellectual property rights came up. The question of intellectual property rights came up. Whether intellectual property rights should be a human right. Eleanor Roosevelt, she was the chairperson of the Human Rights Commission, Universal Declaration of Human Rights. It was headed by the board was headed by Eleanor Roosevelt, and she said that human rights are nothing but freedom from fear and freedom from want. Two things she said. To understand human rights, two things she said. One is freedom from fear. Second is freedom from want. Means every person that is should exercise his rights without fear of the state. And second thing is people must enjoy the economic, social, cultural rights, food, shelter, clothing. So there, one thing was there. That is together with the rights. That is the particular creative activity was also recognized. The creative activity, the creation by a person, painting, writing, all these. So there, that is one clause was added, Article 27. So it says, everyone has the right to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advantage and its benefits. Article 27(2) states, everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. Article 27(2). you come across that the cultural rights, they also were recognized, because in the Universal Declaration of Human Rights, two streams came together. One was the civil and political rights movement. Another was the economic, social, and cultural right movement, which started with the French, with the Magna Carta, the French Revolution, Rousseau, the that is the French school, French Revolution, and ultimately it came to the Universal Declaration. Another was started by Karl Marx. Karl Marx, Angels, when they wrote, because Karl Marx wrote that is civil and political rights have no meaning when the stomach is empty, when you don't have food, when you don't have enjoyment. That is what is the meaning of the civil and political rights, your right to vote. Someone can take away your right to vote. If you are hungry, they give you food and you vote for the party. But that is a different thing. But here, that is our view, is that the particular Universal Declaration of Human Rights, it brought two rivers together. One was the civil and political rights movement. Another was the economic, social, and cultural rights movement, which started by Karl Marx. And after the August Revolution in Russia, that is, it said that civil and political rights are not important, but economic, social, and cultural rights are important. So, Universal Declaration of Human Rights, they brought both the rights together, because one part was supported by one group, another part was supported by another group. So the Universal Declaration could not become a treaty. Universal Declaration could not become a treaty because of the two conflict, Cold War. Later on, 1966, because of the Cold War, two covenants were made: economic, social, and cultural rights, covenant on economic, social, and cultural rights, and covenant on civil and political rights. So some parties, some states, they were members of one covenant, others became members of another covenant. So here, that is, you come across that here, that is after the Universal Declaration of Human Rights, the economic, social, and cultural rights covenant, it reproduced in Article 15.2 the contents of the Universal Declaration of Human Rights in Article 27 of with regard to, that is, moral and economic rights. Now, with regard to, that is, the Delhi High Court, it in some time back in 2016, it stated with regard to the nature of copyright. It said copyright is not an inevitable, divine, or natural right that confers on authors the absolute ownership of the creations. It is designed rather to stimulate activity and progress in the arts of the intellectual enrichment of the public. So the courts, they have accepted that intellectual property is not a divine right. It is not a natural right. It is a right given by the state. Natural right, it is not a human right. It is a right given by the state in order that the people can contribute to the development of the state, economic development of the state, moral development of the state, moral development of the public. That's why the right is given. It can be taken away. It is given by the state. It can be taken away by the state. It is not a natural right. It is not a divine right. It is not a, that is a, it did not talk about human right, but it said that it is given by the state and can be taken away by the state, and it is given for a particular purpose. But human rights are different. Long time back, you come across one case, ADM Jabalpur versus Sukla, 1976 and 1975. You come across where that is Justice Khanna. Justice Khanna is one of the well-known judges of the Supreme Court. His nephew is now the Chief Justice of the Supreme Court of India. Justice Khanna, that is in ADM Jabalpur versus Sukla, he gave the dissenting note when the entire court said that the fundamental rights, including right to life, can be taken away during emergency. But Justice Khanna, he wrote that the right to life is and liberty is not given by the state. Man is born with the right to life and liberty. State cannot take away those rights. And after giving the judgment, before he gave the judgment, also he wrote to his, that is one friend, that I am giving the judgment dissenting note, and I know that I will not be elevated as Chief Justice. After giving the judgment, he resigned. And now his nephew is the Chief Justice of the Supreme Court of India. So there you come across that human rights, they have a different story. The intellectual property rights, they have a different story. The nature is different. Although that is a universal declaration of human rights, it contains, that is the particular right, that is moral right, and the particular commercial right, but states do not recognize it as a human right. So then we come to that is, what are the objectives of intellectual property rights? So that is first is to profit financially or gain popularity from inventions or creations. That is to give the people moral rights and commercial rights. Moral rights is recognition, and commercial rights is, that is getting money, getting profits from the inventions, from the particular, that is creations of particular persons. When an author writes, when a poet publishes his poems, he wants recognition. That is his moral right. And second, when you write a book, when you write a notes, you want commercial gains. You want the book to sell. So immediately when your book is published, the others will copy, that is some part of it, change the, that is words, and they will publish it. So that is first purpose. Then second is to promote an environment where creativity and invention can thrive by striking balance between the individual interest of creators and large public interest. So second is to create an environment where, that is, two rights are balanced. Individual right and society right. Because individual wants profit. Society wants advancement of science technology, a better life, better quality, better provisions, better environment, better trains, faster trains. They want quick movement. They want quality of life, good food. So on the one hand, that is, individuals want profit. On the other hand, society wants benefits. So intellectual property rights intends to balance the two rights. One is the person who has labored, an industry which has used a lot of money, spent a lot of money, research and development, crores, millions are spent to develop new designs, develop new, that is, vehicles, develop new engines. People are trying to, that is, run vehicles through water. So here generally that is when millions are spent, they must get profit. So here generally exclusive rights are given to the individual to use the particular invention for a profit for a particular period of time. So now the creator's rights, they are protected. Then when a particular that is invention is to be patented, there you come across disclosure. Disclosure means if you want a patent, you have to disclose the formula. You have to disclose the formula before getting a patent. So once you disclose the formula and it is published, everyone can, that is, know the particular formula. They can improve upon it and develop new formulas. And also that is after the period is over, say 20 years for a particular, that is book, 20 years for a particular patent. There generally after the 20 years is over, it comes to the public domain. So everyone can use, say with regard to vaccines, with regard to that is certain drugs, medicines, you come across generic medicines. Government is insisting on generic medicines. One example you come across that Shell-Cal 500. Shell-Cal 500. So it was originally that is patented and that is sold by Cipla. Cipla, one company is there. Then the particular that is in India, Cipla was there. And another company started that is Torrent. Now it is making this Shell-Cal 500. And Cipla, it has another generic, developed another generic that is calcium, which is called as Cip-Cal. So same formula. After the particular period of 20 years is over, generic medicines are available. Same formula, different companies, they give different names and publish, and that is sell the particular, that is drugs. So now people get a choice. That is Cipla, Cip-Cal. If you purchase, it is 92 rupees. And if you purchase, that is a Shell-Cal, which is made by Torrent, marketed by Torrent, there it costs 110 rupees. So same drug, same formula, two companies, they give at different prices. So like this, that is society is benefited. After the particular period is over, it comes to the open market. Different companies, they make the same product. There is competitiveness. And people are benefited. They get the particular benefits, get cheap rates, get varieties. Government is also insisting on generic drugs. That is doctors. That is when doctors prescribe a medicine. That medicine you will find only in the medical store near the doctor's clinic. If other places you go, they will say not available. This medicine is not available. Only it will be available in the clinic just near the doctor, in the medical store just near the clinic of the doctor. So like this, that is people are benefited, individual is benefited, who has created, who has invested a lot of money. So individual interest and social interest, they are balanced. And another thing is there which intellectual property right does. Very often you come across in the Patents Act. In the Patents Act, in different laws you come across that some knowledge is there, that is which is traditional. Some, because people have been using the particular knowledge since time immemorial. The use of turmeric, the use of neem, certain local leaves are there, local products are there, local herbs are there, which people have been using neem has been used as an insecticide. Turmeric has been used also, that is that is on the body. Then some, that is foreign companies, they applied in USA for, that is patenting the particular drugs. So India objected. The matter came up before the World Trade Organization. The WTO is the body which, that is settles disputes. Any dispute, it goes to the World Trade Organization. So there India won both the cases. So this is one of the advantages of intellectual property. Very often traditional knowledge cannot be patented. Some forms of life cannot be patented. By cloning, you can create a new, that is animal, but you cannot patent, and it is prohibited. Cloning human beings is patent. That is, you cannot clone a human being, because if you get one cell of a particular person, you can create a replica of that person. So here you come across that traditional knowledge. Farmers, they have traditionally developed new crops. Even basmati, that is other countries in USA, it was that is people applied for patenting basmati as lasmati, but there India again challenged. So like this, that is many traditional knowledge, they are protected by the intellectual property laws, which prohibits the patenting of traditional knowledge. So these are certain benefits, that is objectives of the particular, that is intellectual property law. First is that moral and commercial rights of the creator are to be protected. Second is individual interest and social interest, public interest, they are balanced. And third is, that is traditional knowledge is protected. Then we come to the advantages of intellectual property rights. That is, a number of advantages are there. It balances moral and commercial interests of the creator against the interest of society. Also, that is economic growth of the country by new discoveries. Now you come across that in China, every home is an industry. They create many things. That is so. 2 days, I think yesterday, or day before yesterday, President Trump of USA, he, that is wanted to change the particular, that is tariff rates with China, because Chinese goods are, that is available at cheaper rates. Chinese goods, and in China, that is the maximum number of patents are there. China has large number of patents. They create many things, they patent it. So like this, you come across that economic growth of the country. China, that is, it has economic relations with other countries. It prepares the particular, that is goods at cheaper rates. Then third is they protect consumers, and that is the different families. So when competition is there, when number of products are prepared, that is through, that is research and development, the particular, that is consumers, they can choose because of the competitiveness. Then for, that is solutions, they find solutions for global challenges, and encourage innovation. People carry on research for new developments. Also, that is, it helps in the development of the culture, because when authors write poems, books, historical research, it brings the culture of the particular, that is group of people or the country or the state into limelight. It brings about a bondage. It brings about the development of culture. and technical information is disseminated. Transfer of technology is there because once the particular person applies for patent, immediately disclosure is there. That's why some companies, they don't apply for patent. They go for trade secrets, especially Coca-Cola. Coca-Cola company, Pepsi, that is, uh, they have not gone for patents because once they go for patents, they can use it for a limited period, and after that, it has to come to the public domain. So in 1977, Pepsi, Coca-Cola company, it had to leave India because Indian law said that you have to disclose. You have to apply for patents, disclose your formula. But the Coca-Cola company withdrew. But now it is available to other agreements. Because that formula, the Coca-Cola powder which is used in Coca-Cola, it is only known to few persons. So technical information is disseminated. Then researchers can use the patent information. Researchers, companies, universities, they can use the patent information which is available once disclosure is there, once a inventor applies for patents, that disclosure is there, then fair competition can be there when different companies, they that is develop different types of products. So these are certain benefits. And also this open source. Open source is when a particular product, it is distributed to used by large number of people. Like that is a SIM card. Yeah, that is the particular usage of the that is which are used the Airtel and all this. And also that is once your intellectual property is registered, it also has a financial value. You can mortgage, you can sell it, and you can raise finance on the particular, that is intellectual property right which you have got. Then disadvantages. First is the creators, they have to spend a lot of money. That is companies, other things, their funding is not a problem. But when individually a person carries on research, he has to spend a lot of money, and that is without any funding. Then very often that is a particular product which is there, piracy may be there. That is once you write a book, send it to the market. Immediately, that is supposing USA, because that was one of the causes for this TRIPS agreement. USA, the book may cost 5,000 rupees. Same book, one copy was brought to India, and in India it was printed, especially medical books, very costly. That is, they were printed and sold at 1,000 rupees. So that foreign publisher, 4,000 rupees loss was there for each book. So because that time the particular protection, unless that is the particular, that is agreement was there between the countries, protection was not there. So TRIPS agreement, 1994, that was one of the, that is, this was one of the challenges before the TRIPS. So piracy became common. One CD or that is a particular cassette, it was available in the market. Immediately, that is, it was copied and sold at cheaper rates, causing loss to the creator. Then decreasing quality, because once you develop a product, send it in the market, unless further research is done and quality is improved, slowly the requirement of the product will come down over the years. So research and development becomes a continuous process. So here that is, unless it is improved, the quality will decrease. Say the design. Supposing car design, over the years, people will look for new designs, new qualities in the particular vehicle, new qualities in the particular mobile. Every year, that is, you come across that people, 2-3 years, they keep on selling the mobile, purchasing another, throwing away the mobile, purchasing a new thing. Because the quality of the new mobile, it is increased. New features are there in the, that is new mobiles which are coming up, new vehicles which are coming up, more safety is there. So people want, that is, the quality to change along with the years. That is, those of our age, we have seen, that is the change. That is till 70s, 80s. No, that is no TV, no mobiles, no Xerox. Go to library, sit in library, read books, write in own handwriting. Then Xerox came. Ultimately, that is TV came later. Then mobiles came much later. Internet, mobiles, all these came later. So we belong to that two the generations. One was the generation without internet, without Xerox, without mobiles, and now that is we have to adjust to the new generation. So life has become easier. Once upon a time, for doing research, that is, we had to visit different libraries where Xerox facilities were not there. All this Xeroxing, copying, all this was not there. We had to write in the own handwriting, take a notebook, write down from the particular journals, books, which are available at Delhi, Calcutta, Bangalore, or that is other places. But now on the net, you can find everything. Just download, make a few changes, and that is, or just put the citation and use it. So a lot of changes were there. Plagiarism was not possible that time. That is all this that very often that is handwriting, typing, and plagiarism also could not be detected. So like this, that is many things were there, and quality develops slowly through research. Once a product is there, if you don't develop the quality, the particular thing will become outdated. Once upon a time, the two cars which were available was Ambassador and Fiat. But now you come across varieties. You come across varieties. People want varieties. And that is, that time, that is Ambassador car. It used to last for 2-3 generations. You welding. It was a heavy car. Just when holes were there, do some welding and change the engine. You could last for long. But now that is after 15 years, you have to change the car because the cars, they don't last long. So like this, lot of changes are there. People want also changes. They want new developments. They want faster vehicles. They want good quality vehicles. They want new designs. So all these things are there, and they generally, that is, when a researcher, unless he improves, unless he continues doing research on the particular thing, he does not, that is suit for, that is his product will not last long. Then the patented products, they are mostly costly. That is, when you go for non-patented products, vegetables, other things, there generally you get at cheaper rates, handmade, village made. Those things are not patented, you'll get cheaply. But once patents is got, there they will include all the costs, and the product will, that is, prices will go up. So these are certain disadvantages for the researcher, for the creator, and also for the society. Then we come to that is the origin of intellectual property law. That is, later on, it came to the international level, but initially it developed within the state. Within the state, especially in Europe, that is earlier the particular creators, they used to protect their own products. But after Gutenberg, he developed the printing press in 1436. There generally that is copying of particular, that is works of art, works of literature, it became quick. So as a result of which, that is duplication of works, it came up. So the first Copyright Act was made in England, which was called as the Copyright Act of Anne in 1709. So here generally that is you come across from that time, slowly that is copyright laws, they developed, trademarks laws developed, patent laws developed. And then that is ultimately it was felt that state law is not sufficient. The state laws which were made for protecting the particular, that is intellectual property, it was not sufficient. So hence it was felt that at the international level, unless cooperation is there, because generally when a book is printed and it goes to another place, immediately that is copies are made and the book is circulated, causing loss to the particular person living in another country who does not know that his product has been copied. So here that is at the international level, the first intellectual property law was made in 1883. 1883, 1886. These two dates are important. 1883, the Paris Convention for the Protection of Intellectual Property. There, that is for the protection of industrial property. So there, industrial property, that time it included trademarks, designs, so patents, all these were included under industrial property. And 1886 was the Berne Convention for the protection of literary and artistic works. So these were the two initial conventions. Paris Convention 1883 and the Berne Convention 1886. One was with regard to industrial property, another was with regard to copyright. So initially, intellectual property was divided into two categories. One was copyright law, another was industrial property law. At the international level, Paris Convention, this was the first major international attempt, wherein that is industrial property, patents, trademarks, industrial designs, utility models, service marks, all trade names, all these were taken into consideration. And after that, you come across that is later on you'll go through details. But a number of conventions were there: Madrid Agreement, International Registration of Trademarks. Paris Convention was revised in 1967. The Budapest Treaty, Hague Agreement, Patent Cooperation Treaty, Brussels Convention, Washington Treaty, Trademark Law Treaty 1984, Patent Law Treaty 2000, Madrid Agreement. So number of conventions are there which will be covered later on by, that is, other academicians. Then the Berne Convention, that was with regard to protection of literary and artistic works. But over time it was felt that literary and artistic works, it was not only the author, but there were other neighboring and related rights. That is, supposing a film is made. So film producer, he has the rights. The music director, he has contributed by composing the music. The person, the singer who sings, he contributes. The person who plays the drum, the person who plays the flute, the person who plays the veena, all of them contribute to the particular, that is, development of the movie. So that is, it was felt essential that their contribution also needs to be recognized, not only the singer. So that is uh, every actor in a movie has a unique way of dialogue delivery. So very often that is, other people in advertisements, they copy the dialogue delivery for, that is, developing their own or improve, that is, marketing their own product. So what is the remedy available? Say Amitabh Bachchan's voice is copied by others for marketing their own products. Same voice, that is, they will make up, that is, uh, give advertisement for the particular product. So how far, that is, the protection can be given? So there are many things that is which are covered by, that is, copyright, neighboring rights, and related rights. So that is what are the rights of other person. So here you come across number of treaties, which later on in detail you come across. Bern Convention, it was that is amended, revised in Berlin 1908, Rome 1928, and Brussels 1948. There was another Universal Copyright Convention 1951, the Rome Convention for the Protection of Performers, Producers of Phonograms, and Broadcasting Organizations 1961. New technological developments, they needed international cooperation. Convention for the Protection of the Producers of Phonograms against unauthorized duplication of the phonograms. After the phonograms developed, Nairobi Treaty on the Protection of the Olympic Symbol, 1981, when the Olympic symbol was used by many people for marketing the goods. It was felt essential that the Olympic symbol needs a right. Use of the Olympic symbol for advertise other things, it should be restricted. 1996 WIPO Copyright Treaty. This was a special agreement under Bern Convention. Then 1996 WIPO Performance and Phonograms Treaty, WPPT. Then 2012 Beijing Treaty on Audiovisual Performances. 2013 Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. So now this was one stream. Then you come across that long back in 1948. That is, it was when the United, especially after 1945, when the United Nations was formed. That time it was felt that international trade, here cooperation must be there among nations. So it was not possible because of the disagreement between states, the developed countries, developing countries, the Cold War, all these, that is hindered the development of international trade organization. So one agreement was made, which is called as the General Agreement on Tariffs and Trade. So its duty was reduction of tariffs, to protection, to make agreements with regard to trade. It was not a body with members, but those who are signatories, they sat together to discuss many things. So number of rounds were held. Discussion with regard to tariffs, with regard to, that is, intellectual property and other things. But that is, you come across that ultimately the last round, the Uruguay round of trips in 1994, it came to an understanding that international cooperation is required. And in 1994, it was felt essential that intellectual property rights are connected with trade. You cannot separate trade from intellectual property rights because till that time, trade law was separate, intellectual property law was separate. But intellectual property has a major bearing upon trade because all this piracy, all this violation of intellectual property rights, duplication of products, marketing, or changing models, using another product without acknowledgement, without permission. So all this generally it was felt that the particular, that is intellectual property right, is essential to be part of the trade dealings. So in TRIPS agreement, that is, it was felt that trade and intellectual property rights should come together. So TRIPS agreement was made in 1994, wherein intellectual property rights and TRIPS, they were brought together. TRIPS, that is the major agreement, and India is a party to the TRIPS agreement. Therefore, after the TRIPS agreement, India had to change all its laws with regard to patents, with regard to copyright. So the TRIPS, its objectives first was to reduce distortions and impediments to international trade and take into account the need to promote competent as well as adequate protection of IPRs, intellectual property rights. This was the first objective, that is distortion, to reduce distortion of and impediments to international trade, and that is promote competent as well as adequate protection of IPRs. Because always the general agreement on tariffs and trade, it that is generally focused upon tariff rates, the most favored nation, equal treatment. So all these, they create distortions. So generally tariff rates are levied in order to protect the internal market. So when tariff rates are increased, there's generally a distortion of the trade is there. Supposing you want to encourage Indian market with regard to a particular, that is say crackers. So generally during Diwali, all the crackers used to come from China. So when you stop trade or you levy excess tariff rates on crackers from China, automatically the cracker market in India, they will get a boost. So also, that is, supposing you want trade with one country, not with another country. So there you can, that is, put high tariffs on one country and lesser tariffs on the other country. Just like President Trump, he declared, that is, he's going to increase tariffs from Indian products. So, but these are, that is generally, they are subject to, that is, TRIPS agreement and agreement between the members. And whenever any, that is, distortion is there, the matter can be taken up before the dispute settlement body of the United Nations, of the WTO, World Trade Organization. So here, first is distortions must be removed. Then second is to enforce intellectual property rights and to ensure that intellectual property rights do not become a barrier for trade. Then reduce tensions by reaching standard commitment to resolve disputes, to establish mutually supportive relationship between the WTO. So mainly the TRIPS agreement, it focused upon, that is, to remove distortions between states in trade dealings, to protect intellectual property rights, to provide a forum where disputes can be settled quickly. So dispute settlement body is there, and whenever a complaint is made, a panel is formed which decides on the matter within a time-bound frame, and that is to establish supportive relationship, discussions, amicable settlement between different countries. So these were, that is the particular, that is the objectives of the TRIPS agreement. Mostly trade and intellectual property rights, they were brought together within a common framework. So now that is uh, Article 8. It provides that the rights of members to adopt measures for public health and other public interest reasons and to prevent the abuse of intellectual property rights, provided that such measures are consistent with the provision of the TRIPS agreement. So Article 8, it gives a liberty to the states that you can adopt measures for public health and other public interest reasons on two grounds. That is, states can reduce the particular, that is the particular TRIPS guidelines. They can relax the TRIPS guidelines, TRIPS rules, if it is in the interest of public health and other public interest reasons. But however, any abuse of intellectual property rights, disputes can be taken up before the DSB. So generally during, that is public health crisis, during the COVID pandemic, where the public health crisis was there generally a lot of restrictions were put on the particular, that is use of drugs, the vaccines, the particular, that is restrictions which were put. That is for vaccine to develop, it takes a long time. But here, because of the COVID pandemic, in the interest of the health, that is many rules, they were relaxed. So now you come across that in the different conventions that were made from time to time, that is focus was upon certain intellectual property rights, especially copyright, patents, trademarks, and industrial designs. But now that is under the particular, that is TRIPS agreement, they recognized different forms of intellectual property rights. That is patents, copyright, trademarks, including service marks. Then one important area was included geographical indications. Geographical indications, they are not individual rights. They are community rights. When a particular geographical indication is there, the entire community, they benefit from the rights. With regard to, that is certain products which are common, which have a characteristics, saris, Kanjivaram, Banarasi. So these generally, that is when the particular word is used, that people understand it to be of a particular quality. Simla apple, Scotch. So they are connected. Rasagulla dispute was there between Odisha and Bengal. So now that is two Rasagullas have been given geographical indication. Kolkata Rasagulla and Odisha Rasagulla. So like this, that is geographical indication, industrial designs, and integrated circuit layout designs. This was also, that is included in the particular TRIPS agreement. Undisclosed information such as trade secrets and test data. So this TRIPS, it comprehensively covered many aspects of intellectual property rights and brought them into the regime of the trade. And for settlement of disputes, the World Trade Organization was to be the body for the settlement where the matters could be brought up and the disputes could be settled. Now, that is the TRIPS agreement has three primary characteristics. First is it lays down standards. Standards means the minimum qualitative and quantitative requirements for that is which each member has to that is adhere to. The subject matter, what is to be protected, when it is permissible, on what grounds. So first is the standards with regard to the quality, the quantity, the term, and that is how to distinguish the different categories of intellectual property rights. What are the categories? How that is the protection is to be given? For what term the protection is to be given? It should be that is commonly followed minimum. The minimum should be followed by all the member countries throughout the world. So India earlier for patents it was 7 years. It had to change it to 20 years. Uniformly, all countries also had to change. For copyright, minimum was lifetime plus 50 years minimum that was prescribed. So India earlier it was 60 years. Now also it retains 60 years because that is 50 years is the minimum. Beyond that also that is protection can be given. So first, that is characteristics of TRIPS is it lays down standards for patents, what is required, for copyright, what is required, for trademarks, what is required. Second is that is it provides for enforcement. That is all the state parties, they have to enforce because generally that is this was the TRIPS was important for all the countries because here generally if you want copyright protection in Canada, if you want copyright protection in USA, that is and you want that is any violation for any violation you want to raise a dispute. So the dispute settlement body is the World Trade Organization. So unless you comply with the requirements of the WTO, you cannot be a member. You cannot file a that is a petition, file a dispute against USA before the WTO because USA is a member, India is a member. Therefore, India filed number of cases. So also USA has filed number of cases against India, which are pending before the World Trade Organization. So this is the benefit that is generally the WTO becomes a common body where disputes can be taken up by the different parties, state parties. And states have to enforce the guidelines through making laws, through implementing the guidelines of the TRIPS agreement. And third is the dispute settlement. This is one of the unique features of the TRIPS agreement. The WTO has a body which settles the dispute between parties. And generally, consensus is mostly that is the basis for the settlement of disputes. There is a panel. Once a dispute is brought up, it is sent to the panel. Panel is appointed. But you'll go into details later on. So TRIPS agreement, it was a turning point in the growth and evolution of intellectual property rights, and intellectual property rights and trade, they came together on one platform. Then you come across that at the international level, number of international organizations are there which play an important role in the protection of intellectual property rights. The important body now is the World Trade Organization. It administers the TRIPS agreement, 1994, and all that is disputes with regard to tariffs, with regard to that is unequal treatment, with regard to increase in tariffs, with regard to trade distortions, the matters can be brought up before the World Trade Organization. And World Trade Organization, it lays down norms which are to be applied to the different states. Then there's another body, World Intellectual Property Organization, that is which was established at Stockholm on 14th July 1967. So here generally that is WIPO has incorporated United International Bureaus for the Protection of Intellectual Property. That is, this was the body which was established by the Paris and the Berne Convention. So this was that is brought into the purview of the World Intellectual Property Organization. So you have some countries which are members of both WIPO and TRIPS, and also countries who are members of that is TRIPS but not members of the WIPO. So the purpose of WIPO are twofold: to promote the protection of intellectual property throughout the world through cooperation among states, and where appropriate in collaboration with any other international organization. And second is to ensure administrative cooperation among the unions. So this you come across that the WIPO and the WTO, even though two bodies are there, but the dispute settlement mechanism lies with the World Trade Organization. And also during the pandemic, you come across that one body played an important role in bringing about cooperation among the different states, giving guidelines, and that was the World Health Organization, especially with regard to medicines, with regard to drugs. That is World Health Organization. It plays an important role with regard to the distribution of drugs, the circulation of drugs, the sale of drugs, and the developing and developed countries with regard to the particular, that is, provision of drugs. And then just briefly we'll go through, that is the different intellectual property rights. Although in detail you'll come across later when the other academicians will be talking in detail about the different rights which are provided under the TRIPS agreement and under the Indian laws. So first is copyright and related rights. This is the most common, which has been there since earlier times. And copyright, it has been here, neighboring rights have been included, which includes sound recording, performances, and other works seen as needing less protection than copyright. Then performers such as singers, actors, phonogram producers, and broadcasting organizations. Then here the rights which are provided for copyright are rental of the works, at least in respect of computer programs and cinematograph acts. They can sell the product, they can sell the rights, they can transfer the rights, they can allow other people to use the rights, and the term generally is the lifetime of the author and 50 years thereafter, minimum 50 years. In India, we have 60 years. And in India, the law is, that is, copyright is regulated by the Copyright Act 1957 as amended by the Copyright Amendment Act 2012. It protects literary works, dramatic works, musical works, artistic works, cinematograph films, and sound recordings. I'm not going into the details. You'll come across these later on. Then patents. Patents are granted for inventions which satisfy the requirements of general novelty, non-obviousness, and industrial or commercial application. So, general novelty, non-obviousness, and industrial or commercial application. And earlier in India, that is for certain products. Only that is for certain inventions, only process patents was given, especially medicines. But TRIPS agreement, it says that for medical and other things, that is both product and process patents must be given. So India had to change, amend the laws, and now that is for medicines. That is both process and product patents, they are given for all products. So here generally you come across that in India, Indian Patents Act 1970, earlier it provided that for 7 years, a person, creator or inventor had a patent, and after that period, it came into the public domain. But after becoming a member of the TRIPS, the Patent Act was amended in 2005, and the provisions of TRIPS agreement they were brought in, and Indian Patents Act was amended, granting patents for a period of 20 years. So here generally that is uh, the authority for this is Controller General of Patents, Designs and Trades. Then the third type is trademarks. Trademark is generally a symbol which distinguishes a product from other products. So very often you come across that this also that is under the sale of goods and other commercial laws, they also that is deal with trademarks. But here generally that is whenever there is a use of a symbol, trademark of a particular company, trademark of a particular goods, trademark of a particular services by any other person, any other company, then generally that is the matter injunction can be given and a dispute can be taken up before the courts. Then industrial designs. It refers to the aesthetic or artificial component of an object. So a vehicle, a car, Ambassador car, Maruti car, Hyundai or BMW, every car has a unique design which distinguishes it from other vehicles. So here this design, that is, it also is subject to protection. So also with regard to that is other areas, that is buildings, or with regard to other mechanisms, say mobile, television. So everything that is has a design which is made to appeal to the eyes. So copying that design also that is a violation of that is intellectual property rights. And we have this Design Act 2000, which supports innovation and helps in safeguarding both manufacturers and consumer interests. Then you come across geographical indications. These generally that is relate to that is the particular product which is connected to the place of origin and can be labeled by that place of origin. So here generally once the GI tag is given to a particular product, only those products which have that same characteristic which are originated from a particular place, they can use the particular GI tag. So that generally that is the geographical indication of goods, Registration and Protection Act 1999. Number of disputes have come up, and that is uh, with regard to that is GI tag, which gives importance to a particular product belonging to a particular area. Then this microchips have integrated circuits, that is a layout design. Each microchip each has a unique design. So this integrated circuit, that is in that number of that is semiconductors, capacitors, transistors which are there, and they are fabricated. So in this generally the microchip or the integrated circuit for each product is unique. So here also that is it is recognized as is intellectual property right, and that is the violation of it is a violation of IPR. Then trade dress. This is one thing which comes up. Trade dress means the characteristics of the visual appearance of a product or its packaging or even the design of a building that signifies the source of the product to consumers. that is the packaging of the particular product. When it is uh, sent to the market, a particular building may have a particular design. So once it goes to the market, that also gets protection as a trade design. So also confidential information. Confidential information is the because every company, every that is a industry or factory, they have certain confidential information, especially with regard to the clients, to with whom they are dealing, who are the direct clients, how they manage to get the particular that is clients, how they market the products, the channels they use. So all these information, they become important. Then certain issues are there with regard to that is uh, in India with regard to intellectual property rights. Many issues are there. Some we can discuss. So one issue is with regard to evergreening. Evergreening, you will come across many cases which have come up wherein that is when a particular product, say a drug, medicine, supposing a particular medicine is used for a particular purpose or has a particular composition and that is patented. Then after the period of 20 years is over, supposing a minor change is made, supposing you have this uh, with regard to that is if a product has say penicillin plus uh, vitamin D or something, two elements are added together. Then after some time, that is you come across the product maybe that is paracetamol, that is paracetamol. Then together with that, they may add zinc and also that is magnesium. So whether this will be a new product or supposing a particular drug, that is it is used for a particular purpose, but another purpose is found out later. Say Disprin. Disprin, it was used as a painkiller, but later it was found that Disprin also that is thins the blood, as a result of which within 7 days heart attack will not be there. So whether finding a new benefit of a particular drug, whether it can be patented or not. So that is generally the Indian Patents Act. It prohibits the granting of patents for inventions involving new forms of known substances unless there are significant differences in the substances properties regarding efficacy. So many of the applications, they were rejected. Then another problem that comes up is with regard to this compulsory licensing. Unless it is used in a proper manner. So compulsory licensing, that is when a particular product is needed. Say with regard to COVID pandemic, when a particular medicine is required, but the company is not producing the medicine. So in this case, this compulsory licensing can be used, giving license to another party, that is to company to produce the particular drug and get royalty. So generally, many foreign companies, they do not, that is apply for patents in that is countries where this compulsory licensing is used very often, because through compulsory licensing the particular formula of the particular product is it goes to the particular parties, and once they get the formula they can use little bit changes and that is get a patent for it. So uh, then another problem which you can discuss later on when you come to the subject is that is you have other acts, say Protection of Plant Varieties and Farmers Rights Act 2001. So this Protection of Plant Varieties and Farmers Rights Act, here generally it protects the plant breeders on the one side and the farmers' rights on the other. So once that is farmer, that is the particular, that is Plant Breeders and Farmer Rights Act. There generally the particular, that is plants cannot be patented. Once it comes, that is, it is a plant variety, it cannot be patented under, that is the particular, the Patents Act. So here there was a dispute. You come across Monsanto Technology LLC versus Nuzividu Seeds Limited, 2011. So here the dispute was with regard to protection, whether protection under Patents Act can be given, or that is Patents Act, the patent should be cancelled because it is a plant variety. So in this case, Monsanto Tech was holding a registered patent for nucleotide acid sequence NAS containing Bacillus thuringiensis BT gene. When the gene was inserted into the DNA of cotton seeds, it killed both bollworm from inside the seed. So this the particular BT gene, the NAS, when it was inserted into the seed, cotton seed, it killed bollworm inside the seed, and that is the production was better for cotton. So that is the defendants, that is Nuzividu Seeds Limited. They, through an agreement, they had got the rights for 10 years to, that is, produce cotton seeds. So here, that is after the 10 years period, that is the Monsanto Technology, they cancelled the license in 2015 November. So now that is, they filed a case for injunction, and the particular party will not be allowed to use the particular name of, that is the particular seeds which are used. So that is the trial court. It granted injunction that this Monsanto Technology, it had the patents. Then the matter went before the High Court. So High Court said that it reversed the order. It said because it is a plant variety, even though DNA is inserted, it is a plant variety. Hence, that is, patents cannot be granted, and the Nuzividu seeds, it can continue. Then both parties went to the Supreme Court. And Supreme Court, without discussing, without, that is looking into the matter, whether insertion of a DNA into the seed, it amounts to a plant variety or not. That is, plant variety is there, the seed is there. That is, whether insertion of DNA and changing the chromosome of the particular seed, that amounted to, that is, patents, or it was a plant variety after the DNA was entered. Without discussing that, it sent the matter back to the trial court for taking evidence and other things. This was an opportunity where the Supreme Court could have decided between the two, that is, plant varieties and farmers' rights, the rights under the Plant Varieties and Farmers' Rights Act 2001 and the Patents Act, whether the plant varieties, that is, could be patented or not. When, that is, technologically, the plant variety has been changed. Then during COVID-19, that is, although that is mRNA technology was used, RNA technology was used, that is generally for the development of COVID vaccines. So during COVID period, that is, lot of relaxation was there, and mRNA was, that is, many companies, they were allowed to use the mRNA technology for the development of vaccines. So Pfizer, BioNTech, and Moderna, they used the technology for developing, that is, the vaccines. So now, that is, after the COVID period is over, that is, the particular Moderna is developing the particular that is technology using RNA for other vaccines also. So here the question comes up, although it has not yet been disputed, but questions come up that whether a relaxation given during a particular period, it can be continued after the period is over. That mRNA technology which was allowed, because that time pandemic was there, the government wanted vaccines. Even relaxation of the particular period of testing, it was reduced. Although that is now lot of side effects have been, that is people, that is doctors are saying side effects are there of the particular use of the vaccines. But that is a different thing. But when a particular relaxation is there for a use of a particular, that is the mRNA, which was not patented by and used by different companies, whether companies can carry on the particular, that is technology, after the COVID pandemic is over. So these are that is an introduction to the particular intellectual property rights. And intellectual property rights, that is, they have now entered into the trade arena. They are connected with trade. And once that is the intellectual property rights are created, they give benefits to the individual and also benefits to the community. But advantages are there, disadvantages are there. But on the long run, new technologies, new techniques, new products, they are brought to the market because of the intellectual property rights. So I thank you. Anyone wants to speak anything?
Dear participants, sir, can we take few questions?
Yes, sir.
Dear participants, if you have any questions, you can raise your hand and ask, or you can post it in the chat box. Yeah, please, Ramya, you can ask the question.
So very good afternoon, sir. This is Ramya. Sir, I just wanted to know, am I audible?
Yes, sir.
Yes,
I'm
Ramya.
able to hear.
Sir, I just wanted to know, we have a lot of conservated variety of plants. I mean, the old varieties of plants. In that, when the infusion that it is taking place, the diffusion that it is taking place because of the intervention of biotechnological development, in that the new varieties, though it has been introduced, it has some health impacts also. Can we still bring it within the meaning of a new plant variety and recognizing them? And if it causes some health injuries, who will be taking a call on this?
You wanted to know about the new plant varieties.
Yes, sir.
So
The new plant varieties, where shall I just make it a little clear? New plant varieties that has been made by having the diffusion with the existing variety, where it has also been identified that it might have some health issues at present.
because under the particular, that is Protection of Plant Varieties and Farmers' Rights Act, and
Yes,
also
sir.
that is 3J of the Patents Act. Under Patents
Yes,
Act,
sir.
plant varieties cannot be patented. So
Yes,
in
sir.
that case, the Newspeed case, the matter went up to the Supreme Court,
Yes,
but the
sir.
Supreme Court left it open. Supreme
Okay,
Court
sir.
said that case by case it has to be discussed whether it is a new plant variety or that is, they asked the trial court to take expert opinion on the particular matter. Supreme Court could have discussed, but it left the question open. So now, case by case, it has to be discussed whether it is a plant variety or just a change in the particular, that is particular, that is plant variety, through the introduction of a particular, in that case, the particular bacillus. It was introduced in order to, that is, kill the germs inside the particular cotton seed, so that that bollworm, it could not develop. But plant varieties, they cannot be patented
Understood.
under
Sir.
the Patents Act.
Yes, sir. Yes, sir. Understand. Thank you, sir. Thank you so much.
We also have another law, Biodiversity Act, because
Yes, sir.
these laws, they conflict with each other.
Yes, sir.
Any more questions? Yeah, Ramani ma'am, you can unmute yourself and can ask.
Yeah,
Ma'am, please unmute yourself, ma'am.
I have unmuted actually.
Yes, audible.
I'm not audible.
Yes, audible. I am
Oh,
able to hear.
yes, yes, yes. Sir, I just wanted to know that, like, if any action taken against for sustainability. So for
Sustainability of
sustainability, like anything, you can say that plastic ban and all. So is there anything? Can we go through any this one IPR?
actually IPR, that is, it provides that anything which is harmful to health, because there are number of exceptions, that is, which cannot be patented, which are dangerous, or with, that is, which that is go for illegal activities. So those things cannot be patented. So, and in the Patents Act, you will come across, that is section 3, 4, that is, they provide what cannot be patented.
Okay.
In detail, you will come across when you discuss patents and what patented, what can be patented. It must be new, novel. There must be an inventive step, and it must be, that is, can be used for commercial purpose. But another list is there, what cannot be patented, when it is harmful to public health, when it is that is causes destruction or harmful to life, or can be used for illegal purpose.
Okay. Got it, sir. Got it. Thank you,
I've
sir.
given the introduction. Now, when you go, when that is faculty comes for teaching patents, he will give the details about Patents Act and what can be patented, what cannot be patented. But generally, that which is harmful in public interest, against public interest, those cannot, or to life, they cannot be patented.
Sir, patent also includes, patent or any IPR includes about limitation in production or something. Is there any limit in production?
No, that depends upon the patent holder and the person who gets the agreement. He can limit.
Okay.
But here, generally, once patent is there, generally, that is, he can produce, he can use it for commercial purpose. He can produce, that is, a large number also, less number also. But if the state wants that more production should be there, supposing for 1 lakh people only he's producing be able to produce 1,000. So there, one provision is there, compulsory licensing.
Okay.
The state can ask another person, you produce another 9,000. So state can regulate.
Okay. Thank you, sir.
Okay, thank you.
Sir, there is a question in the chat box. Sir, can plant varieties be registered for geographical indications protection?
Uh, Actually, geographical indication, if new plant variety is created and it is confined to a particular area, because some plants are there which which do not grow when they are taken out because of the climate, because of the particular that is soil of the area. That plant can only be found in the particular area. In the particular area region, because certain types of fruits are there, certain types of flowers are there. It is linked with a particular region, but slowly these seeds are taken to other parts and they are grown there. But generally, when people say Rudraksh generally in the Himalayan area, certain areas are there. But now the seeds are brought in hilly tracts also, that is now they are produced. But that people of that area, they can apply that both for plant variety and also for geographical indication that this Rudraksha is originated from this area. Because if that is, they can show that it is particularly concerned with a particular area and cannot be that is grown in other areas, there it can get geographical indication tag, the product. Geographical indication as well as the plant can get a plant variety tag. Rudraksh or the particular apple.
Okay, sir. Okay, sorry, sir. Ma'am, do you have any observations to share? Ramani ma'am is messaging something. Ma'am, your voice is too low. Ma'am, you are not audible.
Upor. Voice is not.
Sir, may I ask you one doubt?
Shyamjit, please wait. I think. Ma'am, Ramani ma'am, you can type it in the text chat box. Ramani ma'am, your voice is not audible to the resource person. Yes, sorry. Sir, is it audible to you?
No, cannot hear.
It's not clear, ma'am.
Krishna, allow ma'am to type it in the chat box. In the meantime, you can take questions from other participants.
Yes.
Because we have another session to follow. So
Yes. Ramani
any
ma'am,
other
you please
queries?
type it in the chat box. Mr. Shyamjit, you can ask the question.
Or otherwise, if any other query, they can communicate to us. LKDF sir is always in connection with me. I will forward it.
Yes.
Sir, my question is, recently India have initiated nano urea by IFCO. So whether it promotes fair competition in the agriculture industry or will it create a monopoly that hinders innovation and affordability to farming sector?
No, if patents are granted, then generally they can use it, even though because purpose of patent is granting a monopoly for a particular period of time. But if it can be proved that it is harmful to the environment or other things, then the patent can be cancelled. But once patent is like a monopoly, a patent, he has certain rights. He can sell, he can use it, he can develop the particular products. Because patent grants a monopoly to the particular owner of the intellectual property right.
Okay, sir. How can we try to let the government?
No, you can file a case or send an application to the patent office stating that it is harmful. Because generally, before granting a patent, the particular formula, everything is published. So that time, that is the parties or the persons who are affected, they can raise objections. Objections
Recently,
can be raised.
Bharat Urea has been launched, but in that this nano urea is being not included. So this will hinder farmers to purchase this also, like, and also affordable other nano urea technologies are hindering. So I believe there is some
And
issues with that.
no, you can, on behalf of the people, you can file a case. That is, or file it before the patent office, or that is in the court, you can take up the matter, or public interest litigation, you can file. Because once
Thank you, sir. Thank
that
you.
monopoly, once patent is given, the monopoly is there. After that, you have to prove that some harm is there, public interest is hampered.
True,
Okay.
true. Thank you, sir.
Okay.
Okay, dear participants, due to the time constraint and our next session, we are closing the question session here. But if you have any doubts, any questions, you are free to approach us. We will forward it to Lalit sir, and we will get it clarified for you people.
And also,
Sir,
there's a
thank you.
patent session, I think, there they can get details.
Yes, sir.
There's a session
Yes,
of patents, I think.
yes. Sir, it is truly a pleasure to listen to you, sir. On behalf of our Department of Law, Central University of Karnataka, it is my privilege to extend a heartfelt gratitude to you, sir. Your expertise and engaging delivery have not only deepened our understanding of IPR, but also shed light on its relevance in today's world. You have covered all the aspects of IPR as well as the practical examples you have given made this complex topic more accessible and thought-provoking, sir. We are truly grateful for your time
Thank you very much.
uh, and knowledge and expertise, sir. Thank you very much, sir.
Thank you all. Have a nice sessions
Yeah.
ahead.
Yes.
Thank you very much.
Yes.
Thank you,
Thank you,
sir.
sir.
Thank you very much, sir,
And
for accepting the
and
invitation and working, dedicating your valuable time for us, sir. Thank you, sir.
yes,
Thank you.
yes.
Thank you
Dear
very much.
participants, we will start join the session at 2 p.m. sharp for the post-lunch session. Please kindly cooperate with us and join in time. Thank you.
So, Krishna, please close the recording.